Ready? We'll call the Monday, November 10th Commission meeting to order. If you would, please stand for the invocation and pledge. Dear Heavenly Father, we come to you this evening. We ask that you give us wisdom to make the best decisions for our city of Leesburg. In your precious name, amen. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have no proclamations or presentations. We will move to public comments. This section is reserved for members of the public to bring up matters of concern or opportunities for praise. Please note that issues raised during this time will not be discussed in detail during the current meeting. They will either be referred to the appropriate staff or scheduled for consideration at a future City Commission meeting. Each speaker is allocated 3 minutes to provide their comments. Kindly adhere to this time limit to ensure equal opportunity for all participants and to support the efficient conduct of the meeting. Thank you. Are there any public comments this evening? Seeing none, we'll close public comments and move to the consent agenda. Routine items are placed on the consent agenda to expedite the meeting. If the commission or staff wish to discuss any item, the procedure is as follows. 1, pull the items from the consent agenda. 2, vote on the remaining items with 1 roll call vote. And 3, discuss each item pulled and vote by roll call. Are there any items the commission would like to pull this evening? Seeing none, I'll take a motion to approve the consent.
I move that we accept the items listed, and this consent is listed.
So we have a motion. Second. We have a motion and a second. Any further discussion? Any public comments? Seeing none, roll call.
Commissioner Connell?
Yes.
Commissioner Burry?
Yes.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Mayor Reesman?
Yes. Moving on to public hearings and non-routine items. During public hearings and non-routine items, the commission requests that those in attendance respect the process and maintain order. As such, in accordance with Robert's Rules of Order, please refrain from speaking out, cheering, or applauding during these proceedings. Your cooperation helps ensure a fair and respectful hearing. I would now ask that our city attorney swear in anyone speaking on any of the first or second readings this evening.
Yes, sir. Thank you, Mr. Mayor. Anybody here who's present this evening who would like to speak on item 6A3, which is the Oak Ridge PUD rezoning second reading, or 6B1 banning 5 PUD rezoning first reading, if you would please stand and raise your right hand so you can be sworn in. You swear or affirm that all testimony you'll give tonight will be the truth, the whole truth, and nothing but the truth? I do. All right. Thank you all. You're ready, Mr. Mayor.
Thank you, City Attorney. Would someone please introduce 6A1, 2, and 3 to be read by title only?
I'll introduce, ask to be read by title only.
6A1, an ordinance of the City of Leesburg, Florida, annexing certain real property consisting of approximately 596.29 plus minus acres, being generally located east of County Road 48 and south of Ronald Reagan Turnpike, lying in sections 28, 29, and 32, Township 20 South, Range 24 East, Lake County, Florida, providing that said property so annexed shall be liable for its proportionate share of the existing and future indebtedness of said city, providing that such annexed property shall be subject to all laws and ordinances of said city, as if all such territory had been a part of the City of Leesburg at the time of passage and approval of said laws and ordinances, providing that such annexed territory shall be placed in City Commission District 3 and providing an effective date. 6A2, an ordinance amending the future land use map of the comprehensive plan of the City of Leesburg, changing the future land use map designation of certain property containing 596.29 plus minus acres from Lake County Rural to City of Leesburg Estate Residential for property generally located east of County Road 48 and south of Ronald Reagan Turnpike, lying in sections 28, 29, and 32, Township 20 South, Range 24 East, Lake County, Florida, and providing an effective date. 6A3, an ordinance of the City of Leesburg, Florida, changing the zoning on approximately 596.29 plus minus acres from Lake County A Agricultural to City of Leesburg PUD Planned Unit Development to allow 910 single-family attached and detached units for property generally located east of County Road 48 and south of Ronald Reagan Turnpike, lying in sections 28, 29, and 32, Township 20 South, Range 24 East, Lake County, Florida, and providing an effective date.
Motion to approve.
Second.
We have a motion and a second. Thank you. Mr. Miller?
Thank you, Mr. Miller. Dan Miller,
Thank you, Mr. Mayor. Dan Miller, Planning and Zoning. This is the Oak Ridge PUD. Under the background for this project, it's generally located east of County Road 48 and south of the Florida Turnpike. The project does include an annexation, large-scale comp plan, and rezoning to PUD. The site consists of approximately 596.28 plus or minus undeveloped acres. The request is for future development of 910 attached and detached single-family residential units and associated amenities. The overall proposal gives us a comp plan request of county rural to city of Leesburg estate density residential, and the zoning request would be from Lake County agriculture to city of Leesburg PUD. Under the PUD requirements, the proposal consists again of 910 single-family units split into two home types. There would be 642 detached single-family units plus 268 villa units, which are the duplexes. There are no other uses permitted. For the detached units, there will be 83 of those that are scattered around the exterior boundaries on 60 and 70-foot wide lots with 1,700 and 1,800 square foot houses. And this is again around the perimeter of development. And then the remaining 559 units will be on 50-foot lots with a 1,500 square feet living area as defined under roof. There are architectural and design standards required and that are shown in the exhibits that you have in front of you. 2 floors is the maximum height. Each house has to have a minimum of 2 off-street parking spaces. 35% of the property is required to be in open space. There is much more actually than that. The dark sky lighting is required and trees in each yard. There's a 25-foot landscape buffer required along the entirety of the property boundaries except where it is not needed due to an existing wetland area where the property backs up to a marsh. There's a 3-foot berm, 4-foot fence along County Road 48, and also a fence along the perimeter, again, except for where there's a berm or a wetland present, it's not needed. There will be sidewalks throughout the development. Use of Bahia or Bermuda grass is required in place of St. Augustine. Under site access and signage, there is access shown along the County Road 48 on the site plan and will be required to have all the applicable requirements for turn lanes, accel, decel lanes, et cetera, from Lake County. The main access point in the front is required to be a boulevard-type roadway with a landscape median of at least 8 feet in width and enough width on each of the lanes in and out to allow emergency vehicles to maneuver. There will be signage in the front, which is required to be a decorative entryway feature, concrete, brick, or stucco that is at least 5 feet in height on each side of the entryway, or they can have that within the landscaped area at the boulevard entrance. There is interconnectivity between this subdivision and the adjacent subdivisions. And I wanted to point out that to the north of this proposal, there's the intersection of County Road 470, 48, and 33. Depending on the time of day, as all of you have heard, this is one of the busiest intersections and most difficult intersections to get through. At this time, while I don't have specific details, staff is aware that there are developers who are working on this intersection of County Road 33, 470, and 48 in that area. We do know that they are working together to have some studies done, some signal warrants, and review of potential funding mechanisms. So the development community itself is working toward planning for improvements for that intersection. In the long haul, that will require coordination between the city, the county, and developers working together, and staff will provide you with updates as we get them. I just want to let you know that there's a lot of thought being put into that. I believe the county also has some money earmarked for that intersection as well. Under recreation, this PUD does require 4.18 acres with a pool, cabana, children's park, playground, dog park, those kind of things. And there's a walking nature trail which is designed to blend into the neighborhood and the wetland areas. For utilities, everything is on City of Leesburg water and wastewater, so you have no well or septic on the property. And then finally, of course, there's the phasing or expiration clause, which requires that the development move forward with substantial commencement within 4 years, or it reverts to a 1 acre per unit zoning requirement. Mr. Logan Opsel of Lowndes, Doster, Cantor, and Reed of Orlando is here to represent the case and answer any additional questions you may have.
Thank you, Mr. Mayor.
Thank you, Mr. Miller. Any questions for Mr. Miller before we proceed to the developer? Thank you, Mr. Miller. Would the developer like to say anything?
Good evening, Mr. Mayor, Commission. Logan Opsahl, 215 North Eola Drive. Good to be with you on a chilly evening. Y'all know this project and have seen a couple, 2-3 times, so I'll be brief. First and foremost, I want to address, we're here tonight. We continue to a date certain from our last second reading. We received a county letter addressing various maintenance obligations on 48. I know you have discussed and have likely been updated as well from the city attorney that the city has provided a response to that letter. The applicant team did as well because much of it was project specific. So we are in agreement on our interpretation of those items, and our understanding is the county will maintain ownership of 48. So we're mindful of those things. Again, I addressed some project specifics, which included other matters specific to this project in relation to the ISBA that was cited by the county, including the intent and design of which to remove enclave areas such as this property. Madam Clerk, would you mind pulling up just the slide? Again, y'all have seen this, but I want to just touch on one or two, and then I'm happy to answer any specific questions and leave some time to respond. Thinking about it. Thank you. There we go. Thank you. So Dan touched on his staff presentation, the amenities being provided here for this activity. We have a minimum of just shy of 5 acres of amenity space for the pool cabana. The main amenity here is the nature trail and the multi-use trail throughout the project, which showcases the wetland areas and the areas of wetland that will be created as part of this project. These things amount to 70% open space across the property, and adding additional landscaping, natural vegetation to really set out some proper stormwater management out there that does not previously exist. And again, the creation of some wetland and expansion as well. With that, I'm happy to answer any specific questions. Again, I know y'all are well versed in this project, and happy to respond to any questions or comments we receive from the public as well. Thanks for your time.
I did have one question. I read the letter that you guys sent
Yes.
Commissioner Campion. Did you have any response back from?
No, sir. I did
No,
not receive. No, sir.
Nothing. Okay.
No, sir.
Thank you.
Thank you. Yes.
And we got one letter from the attorney back, is that correct? Basically saying,
No, we got Chairman Campion's letter, and then that was returned with my email to the county manager, and then she returned an email,
There you
which
go.
we
That's-
submitted to you and
right,
and
that's what we
forwarded to
read.
the
So we've seen
petitioner.
everything that has been generated,
Yes.
basically.
All right, any other questions for the developer? All right, we're going to open up to public comments at this time. Are there any public comments regarding these items? No public comments. We're going to close public comments. Before we bring it back to a vote, any final comments from the commission?
I did have one thing I want to mention. Dan had noted that the intersection of 33 and 470 and 48 is really bad, and it's absolutely horrible, especially in the morning and afternoons. And there is some, I guess, some talks going on and maybe addressing that intersection. I think it'd be a good idea not to put any more traffic on that intersection until it's actually addressed and corrected. Talking about another 1,000 homes here at that intersection. I mean, there may be some talks, but who knows how far down the road that intersection is to be addressed. I'd like the rest of the commission to consider not putting any more traffic at that intersection until it is completely redone, versus putting another 1,000 units going through there.
Any other comments from the commission? All right, we will vote on 6A1.
Commissioner Berry?
Yes.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Commissioner Connell?
No.
Mayor Reason?
Yes. We'll take a vote on 6A2. We need a motion to approve 6A2.
Motion to approve 6A2. Second.
We have a motion and a second. Any further discussion? Any public comments? Seeing none, roll call.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Commissioner Connell?
No.
Commissioner Berry?
Yes.
Mayor Reason?
Yes. Can I get a motion for 6A3?
Motion to approve 6A3.
Second.
We have a motion and a second. Any further discussion? Any public comments? Seeing none, roll call.
Commissioner Berry?
Yes.
Commissioner Connell?
No, not to allow 910 units.
Commissioner Berry?
Yes.
Commissioner Peterson?
Yes.
Mayor Reason?
Yes. Would someone please introduce 6A4?
I'll introduce and ask to be read by title only, please.
Thank you.
An ordinance of the City of Leesburg, Florida, amending the boundaries and changing the name of the Grace Key Groves Community Development District established pursuant to Ordinance 24-33 to Grace Grove CDD, providing a severability clause, addressing conflicts, and providing an effective date.
Motion to approve.
Second.
We have a motion and a second. Mr. Miller?
Thank you, Mr. Mayor. This is a request for an ordinance to amend the boundaries of the Grace Key Groves Community Development District. This was established under Ordinance 24-33 in July of 2024. This CDD does serve the Bar Key subdivision, which is located off of Dewey Robbins Road, lying generally east of U.S. Highway 27 and south of Dewey Robbins Road. This is basically just adding in 39 acres. The request will revise the area of the Community Development District from 691 to, I think, 718, give or take, acres. The property in question is 39 plus or minus acres. It's fully contained within the Bar Key project. It was recently zoned under the Bar Key conditions as Bar Key 2 under ordinance, I have down here as 2267. I think that was the original Bar Key, but we did another one after that for this specific property. So it's simply adding to the existing Bar Key. It's not changing the number of units or anything like that.
Thank you, Mr. Miller. Any questions for Mr. Miller? Any public comments on 6A4? Seeing none, roll call on 6A4.
Commissioner Connell? Yes. Commissioner Berry?
Yes.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Mayor Reason?
Yes. Would someone please introduce 6B1?
I'll introduce and ask to be read by title only, please.
Thank you.
An ordinance of the City of Leesburg, Florida, changing the zoning on approximately 103.14 plus minus acres from City of Leesburg PUD to City of Leesburg PUD Planned Unit Development to allow for 494 single-family detached units consisting of 241 50-foot lots and 53 60-foot lots for property generally located east of County Road 48 and north of North Austin Merritt Road, lying in Section 32, Township 20 South, Range 24 East, Lake County, Florida, and providing an effective date. 241? Oh, I'm sorry.
To allow for 494. That's okay.
All right.
Mr. Miller?
Thank you, Mr. Mayor. This is the Banning 5 PUD zoning. Rezoning only, generally located east of County Road 48 and north of Austin Merritt Road. It's 103.14 plus or minus acres. They're requesting approval for future development consisting of 294 single-family dwelling units. So the request is simply a request for a change in the zoning from city PUD to city PUD with revised conditions. If this is approved by the commission, this will create a spine road interconnecting County Road 33 and 48 via the other Banning Ranch projects, which are all similar to this one, which have been previously approved on this property back east to County Road 33. Again, 294 units on
3.14 acres. The lot sizes are 50 and 60 feet wide. The 60-footers are on the exterior, as we typically do. We have all the same PUD features, including the 5 design features that have to be selected from the PUD architectural standards list: 35% open space, dark sky, landscaping plan, buffers around the project, which is 25 feet around the entirety of the project, basically except where it's not needed due to existing wetlands. 2 floors, 35 feet, sidewalks required. Under site access, again, County Road 48, under Lake County jurisdiction, the developers will be required to make all improvements as required by Lake County and as normally written in our PUDs to support that. Main access will be a boulevard-type roadway, landscape median. Signage will be the standard with the decorative entry feature that we described in the previous project. And interconnectivity with the other subdivisions will be available on this plan as well. 1.35 acres of park and recreational land is required, which does include 1 primary recreation area with 3 amenities. That means a swimming pool plus 2 more, such as barbecue grills, play areas, ball courts, picnic tables. Again, everything has to be on city water and wastewater. And then we have the standard expiration phasing clause, which reverts the property if substantial commencement is not begun within 48 months. And Mr. Andrew McCown of GAI Incorporated in Orlando is here to answer any other questions.
Before we move to the developer, any questions for Mr. Miller?
Thank you, sir.
Dan, we had a PUD on it, right?
Oh, yes, sir. The current PUD had the same, I think, 300 units.
So this is a reduction in
This
units?
is a slight reduction in
overall.
units, and it's all single-family. The previous PUD had townhouses and single-family, so this is a slight reduction.
And the mix of the lots match the other banning?
This mix of lots
Mixes.
matches all the way back to 33 with all
Right.
the other
you.
banning projects. Yes, sir.
Thank you, Mr. Miller. Would the applicant like to say anything?
Thank you, Dan. Andrew McCown with GAI Consultants, representing Hanover Land. And thank you for tonight. And I'll take those extra 200 units if you're offering. So this will be a quick presentation, maybe if the contraption will work. Oh, the other one. There we go. Okay, just a little bit of context. You can see the site indicated by the blue star in between County Road 48 and County Road 33. And zooming in a little bit more, this is a recent aerial of the site. And as Dan mentioned, this was a previously approved PUD, 103 acres, 300 DUs, which broke out to 148 single-family homes and 152 townhomes. But it also included up to 30,000 square feet of commercial. And that plan, when previously approved, had 2 acres of recreation and about 31% open space. So since then, this is the new proposed PUD plan. 294 DUs, a reduction of 6 units. But as Dan said, all single-family homes, no townhomes, which just by itself means a reduction in traffic generation from the previous approved plan. Also, the elimination of the commercial program, also a reduction in traffic generation. This plan proposes 2.5 acres of recreation, which is an increase of 0.5 acres over the previous plan, and significantly more than the 1.7 acre minimum based on the 200 square feet per unit. And then there's over 41% open space as opposed to the 35% required in recent PUDs. So this is the connection of all of the Banning Ranch phases that Dan mentioned before, going all the way from County Road 33 in the east to County Road 48 in the west. You can see the phases proceed from the east to the west, with the Phase 5 being all the way to the west, adjacent to 48. And highlighted in blue is the new spine road that will connect all of the phases together from one county road to the other. And some of the benefits that the city gets from this new spine road is that it obviously will just help distribute the traffic more efficiently between the two county roads. Also allows a much shorter route to the turnpike from County Road 48. So instead of having to go all the way up north to that intersection that everybody hates and then coming back south, you can actually cut through to the turnpike through the spine road. It'll also function as the utility corridor between the two county roads, and also will be an alternative emergency services route between the two roads. Instead of having basically one option, now you'll have additional access. Zooming in just to the development, the Phase 5 development, you can see we're planning 2 phases of the same number of units, 147 units in each phase. And the lot split you can see at the bottom, 241 50-foot lots and 53 60-foot lots. Some of the highlights, you'll see the amenity center on the eastern side of the phase. And this phase would be constructed first before Phase B. You can see the connection to the spine road going out to the east, and then the connection to the adjacent project to the south, which I believe is called Blake Ridge. And then the main entrance on the west with the boulevard-style entrance. Looking at the open space breakdown, you can see there is a significant amount of wetlands and stormwater on the site, and also those 2.5 acres of parks that I mentioned. And then over 10 acres of other open areas that include floodplain and tree save areas, and also a significant amount of landscape buffers. And at this time, I would mention that all of the phases will be essentially part of the same HOA, and will have access to all of the other park amenities in the previous 4 phases that are to the east. So when you see that the amenity in the 2 parks there, the residents here would have access to all of the other parks and amenities in the previous phases. As far as traffic goes, the directional split is anticipated to be about 70 and 30, 70 going to the west and County Road 48, and 30% across to County Road 33. And looking at how that breaks down by existing traffic and approved projects, the green there is illustrating the existing traffic on the road in terms of peak hour trips. And then the tall orange one is every other approved project, including the project approved tonight. So the Oak Ridge project is included in those numbers. And then the red is the Banning Ranch Phase 5 contribution to the peak hour trips. And the blue would be the all the rest of the available capacity by the year 2031. And then likewise, since this, it does have the connection out to County Road 33, we looked at that as well. And this is how that intersection breaks out. The green being the existing traffic, you can see, and again, this is peak hour traffic. And then the orange being all the other approved projects for that road. The red being the Banning Ranch Phase 5 contribution, and then the blue being the available capacity left in year 2031. So the last slide I have is basically a description of the changes to the ordinance that you received in your packet. We had originally requested a 115-foot minimum lot depth for both the 50-foot lots and the 60-foot lots. And in the draft ordinance, 125-foot got in there. And so we're requesting that that be reduced back to the 115-foot lot depth, which would result in those various minimum lot size changes as well, because those minimum lot sizes were for the 125-foot deep lots. So that concludes the presentation. We have representatives from the owner and the traffic consultant, and we're here to answer any of your questions.
Any questions for the applicant?
I have a couple. This is not a gated community?
Not gated, no.
Okay, so, and this, I think you refer to as a spine road?
Spine Road, yes.
It's going to be a regular road that's going to cut through between 33 and 48?
Correct.
And is it going to be maintained by the CDD or the city of Leesburg, or?
It would be maintained by the CDD, I presume.
14-foot travel weight instead of a typical 11 or 12.
Ben Snyder, Hanover Land, for the record. The spine road is contemplated to be dedicated to the city and constructed per city standards like every other project we've done. It actually is a little bit wider with 14-foot travel ways to accommodate the additional traffic and help people move between 48 and 33 to relieve traffic on the other roads.
And it's going to allow sand trucks, semis, everything else run right through the subdivision?
We don't restrict who uses the public roads, Commissioner.
But, okay, so, but you're proposing the city of Leesburg would be responsible for the maintenance of it?
We propose to dedicate the road to the city, and I think it would be maintained like all the rest of the public roads, yes, sir.
I don't know we want to take in more roads, but, and this is, it's already in the city now, what you're, this,
Yes, sir.
when was that PUD done?
You remember the year?
2008, I believe.
2008, PUD.
So is it not expired then?
Those
So it is expired? Okay. So an expired PUD, and how many miles is this spine road?
I don't know the number. I don't know the number off the top of my head, Commissioner.
I'm just trying to think how much roadway you're proposing that we take over.
Is that 5 miles?
I bet it is.
Manning's probably big, maybe
So-
3 miles, 5 miles.
We're happy to get that number for you for the next reading.
Okay, thank you, sir.
Yes, sir.
Any other questions for the applicant? Seeing none, any public comments on this item? Did you have one, Commissioner?
No, not for the applicant. I kind of wanted to go back to Dan on
Yep,
that.
we'll go
you
back
know.
to Dan real quick before you open.
So the 2008 PUD has expired.
Yes, sir.
All right, so
I don't want to jump in, Jimmy, but that would mean, since it's expired, it goes back to the 1-to-1 ratio?
No, because we only started doing that about a year
So
ago.
what's it go back to? What's the deal with it?
It would ideally, let's see, I don't know if I have that copy with me, Mr. Zellwood.
it's the same question. so
Okay,
that's fine.
there you go.
Actually, it's supposed to go back to if anything else happens, if it's expired, then it should go back to the planning commission, who would consider whether to rezone it to PUD or change it to RE1. There was some different wording back in 2008. So it was treated differently back then, but basically that's what they've done, is gone back through the process.
But this didn't go back to the process?
Yes, this did go back through
And
the
what
process.
was planning and zoning's recommendation?
The planning commission recommended denial. Planning staff recommends approval.
Okay, what was P and Z's, they give a reason on their denial?
On this one, let's see, I have it in the notes, because we have so many, Commissioner, I'm sorry, I can't remember all of them.
Not enough open spaces to increase traffic on County Road 48 and 33.
Max, go ahead.
Oh, okay. Sorry. That was the reason for the denial.
They cited concerns, as you said, about open space and increased traffic on 48. Those were major concerns listed.
From the planning, so.
The last thing I just want to say on this, and I know it's first reading, but, I mean, this board just approved 900-something homes already. Here's another, so with this one, I mean, you're talking about over 1,200 homes we're putting back to 33, 470, and 48. All these roads out there are 2-lane roads. I mean, it's going to create a major traffic problem if we keep adding this. The PUD's expired. we got a road that's being proposed 3 to 5 miles or however long it is through this subdivision that they're wanting the city to take basically ownership of and maintenance of. I really hope the commission at the second reading takes all this in consideration.
I have a question, just in general, from our planning side, I guess. So, what importance to city services, meaning police, fire, everything, is having that spine road
For all the,
there in the first place?
yes, sir, for all the reasons that Andrew brought out, Mr. McCown brought out, that road is very important. It will, one of the issues is emergency access. The other is interconnection between 33 and 48 to alleviate traffic that needs to go south either way without having to go up to that intersection. So there's a number of reasons that we do need that spine road that we have to keep in mind. In addition, under the current zoning, which is expired, that's true, but it was still, this is a much better plan, and it allows that spine road to go through and interconnect 33 and 48, which we've never had and will need. It will take a number of years for all this to come to fruition. It won't be certainly overnight.
Any other commissioner comments?
Just one comment. I heard a mention of tractor trailers and so forth. Is there a way to restrict that on this road?
I see no reason why the city couldn't say no through trucks.
And I would ask the developer what they want. I'm just throwing it out for discussion. I mean, it probably won't be as big of an issue when construction, like the villages is moved further along and so forth. But I'm just sitting here looking at that road cutting through residential. I just bring that up for discussion between now and second reading.
Yes, sir.
All right, any other questions for Mr. Miller? Commissioner Morris?
Tim Morris, County Commissioner, District 5, Leesburg, Florida. Y'all are in the catbird seat right now. You can ask for about anything you want. 48 is going to be a nightmare. 80 trips and 147 houses is ridiculous. I don't know where their traffic study came from, but I know at the county level, I'm requesting that we hire our own traffic study people to do the traffic study and get it out of the developer's hands. We're working on that. Ask them to take care of 48 all the way to 33. I mean, 1,200 homes in there, they're making a lot of money. So if they we're doing this with Howie right now. Howie in the Hills has taken some number 2 road, and they're redoing the road all the way into 19. Ask them to take care of 48, widen it, whatever needs to be done, and help us with the traffic, because it's going to be a nightmare. It's already a nightmare in Okahumpka. I couldn't imagine this, and 33 is going to be the same way. So I just wanted to put my comments on the record. Thank you.
Thank you, Mr. Morris. We're going to open it up to public comments. Any public comment? Yes, sir.
You just kind of triggered one more comment, and I appreciate your comments, Commissioner. Once again, just throwing it out for discussion between now and second reading. But rather than the developer take over 48, can we not push back on the spine road and have the developer maintain that road to the city's standards? I just put that out there.
Okay. We're going to open up to public comments. Any public comments on these items? Yes, sir. If you would, please state your name and address for the record, and you will have 3 minutes, sir.
My name's Tim Casey, address 12198 West Gulf Breeze Court, Crystal River. Me and my sweetie bought a lot in Clearwater Lakes about a year ago, and I got a crude picture I can use, but that little orange dot is the lot that we bought, and just really kind of tying with the traffic coming in the area. All the blue, as you know, are approved developments coming into that area between 48 and 33. I added them up. It's just crude numbers, but it comes out to 30,000 units where you see just where the numbers are in that area. So that's really the point I wanted to put out there. You're talking about traffic, 30,000 units in there, not just this one and not Oak Ridge, which you just approved. Thank you.
Any other public comments on this item? Seeing none, this item will lay over to December 8th. We have no non-routine items, informational reports, city attorney items.
Yes, sir. I've got something to go over with the commission this evening. I don't know if everybody has heard about PFAS litigation that is ongoing around the country, but basically there are some lawsuits going on relating to PFAS, which are man-made chemicals that are commonly found in nonstick cookware and some other things, particularly in firefighting foam. It is very prevalent in that and widely used. I don't believe it is, it's a lot more controlled than it was years ago. And so, anyways, all of these PFAS chemicals have sort of found their way into groundwater. And so there is damage and sort of degradation and extra expenses and cost incurred with water system operators treating the water to remove PFAS from the water. And so, many years ago, there were a number of companies that were involved in producing these. Two of those are 3M and DuPont. Now, there is multi-district federal litigation going on against DuPont and against 3M. And so what 3M and DuPont have done is they have created an allocated settlement fund, and they have gone through, and there is a list of water systems that would be entitled to claim money from this fund. Now, this is not a fund where you need to prove causation. It's simply an allocated settlement fund, and if you're on the list, then you're entitled to money from the settlement fund from DuPont and from 3M. The settlement fund only relates to drinking water. It does not relate to sewer, and it doesn't relate to airports. There are potential claims in the future that might be available for those as well, but right now I'm just talking about water system, drinking water. And so that fund right now, I believe, is $13 billion. There's a lot of money in there, and this is a nationwide claims fund. City of Leesburg is on the list. And so the city of Leesburg does have, or sort of is in position to claim money from these settlement funds. The way that it generally works is the source wells would be tested, and then the PFAS level would be scored based on those tests. And then there's sort of a matrix of sorts where you would sort of take those test results, take the number of wells you have in these things, run it through the formula, and it'll spit out a number that the city is likely entitled to. I have spoken to, and so I'll sort of backing up, there are some national law firms that are driving this train on the multi-district litigation, and there are some local law firms that have reached out to me who are working with the national law firms in regards to these claims, asking whether or not the city would like to sign up for their assistance. And so the way this fund works is this was an opt-out claim against DuPont and 3M. So the federal court said, you put up the $13 billion in this fund, then that's it. You guys are free. And so you're not going to be sued by other people. The city does not have the ability to go sue DuPont and 3M for the water system at this point. So from my perspective, there's money there. If the city doesn't make a claim on that money, whatever's left over goes back to DuPont and 3M. And so to me, it really seems like a no-brainer to make a claim here. The funds are unrestricted, and so it could go into the general fund. The city could spend it on water system, could spend it on whatever the city wants to. But basically kind of where we are is I've had a couple of law firms reach out to me, like I said, about signing up. These are all contingency deals, so the city would not be paying money out of pocket. The attorneys would be looking to share in the proceeds of money that they obtain for the city. Typically, that percentage is around 25 or 30%. So it's a pretty hefty percentage, but one of the benefits is they're obviously motivated to try and get as much as they can out of that fund for the city. So at this point, I think what I'm looking to do is, A, kind of inform you guys about what the situation is. And now there are other companies. There are 3M and DuPont are not the only ones. BASF was another one that had recently put up a fund that I understand the time has passed for claiming under that fund. But there may still be a way to get in there. So from talking to the other attorneys, what I understand is basically what they would like to do is make a claim for the city under the drinking water fund, the DuPont and 3M, and try and get as much money. I understand the outlook is 7 figures, is what the estimate is. So we're talking significant money that the city could likely be entitled to. And so we would get what we might get out of the DuPont 3M drinking water fund. They believe that it's a good idea to probably file claims for sewer and for the airport as well, because they believe there will be settlement claim or settlement funds that are established for those as well. Right now, I understand the federal courts are more interested in dealing with drinking water and then dealing with the other stuff after they figure out the drinking water. And so really, we would be making a claim against the DuPont 3M fund, but I think one benefit of sort of being tied in with these attorneys is they know the other claims that are going on. They know the other chemical companies that are potentially exposed as well. And so there could be, this could be sort of the first domino. There could be other settlement funds and a lot of things out there. But I think, like I said, I wanted to let you guys know about this, and I wanted to see if you would like me to continue down the pathway of potentially trying to find us an attorney to help make claims under these funds. With regard to the DuPont and the 3M fund, there's only one deadline that's looming, and that is an end-of-the-year deadline to sign up and make your claim. If you make your claim by the end of this calendar year, then you would be entitled to have testing reimbursed out of the settlement fund. And I understand those tests are about $800 a whack. I don't know how many wells, how many source wells we have and would need to test, but if there's 20, then $800 times 20, it's something. If everything's not signed up by the end of the year, again, really the downside is that you would not be clearly entitled to claim reimbursement of test cost from the settlement fund. You would still be in line to claim the larger sum for the damage to the system, but the test cost would not be reimbursed. There still might be an outside chance of getting it reimbursed, but the clearest way to have those reimbursed would be to sign up before the end of the year. So like I said, I'm happy to field questions to the extent anybody has any. I think what I'm looking for is really just sort of approval to continue down this road and either bring a retainer agreement back to the commission for you guys to look at and decide on an attorney you would like to use, or to retain an attorney. I frankly would prefer to bring it back here and let you guys decide who you want to use. But I do think this is really a no-brainer, and I think that continuing down the road of trying to find one of the local attorneys to help us with the national law firms and make the claim is really probably the right thing to do. And so I would encourage y'all to do that, but like I said, I'm looking for your direction on whether you would like me to continue down the path and potentially bring a couple of retainer agreements here before you all so you can make a decision on what you want to do with that.
Any commission comments?
I have a question. Has there been other cities that have been involved in the area or the county?
Yes, they are actively talking to all of the cities right now that have water systems and airports about these claims and informing everybody and trying to get everybody signed up. Yes, ma'am. I don't know anybody that I could sit here and say has signed up right now. I guess I would say I know St. Cloud has through talking with one of the attorneys. But outside of that, I don't know a specific Lake County city that has signed up. I know several that are talking to attorneys right now.
And if we didn't meet the deadline by the end of the year, will there be another rollout with others, or is this?
Yeah, this is only DuPont and 3M.
Okay.
So
And this-
there could, like I said, I don't know how many chemical companies were manufacturing this stuff, but they basically said, we did it, we know it was harmful to water systems, and so we're going to put up a gigantic chunk of money to pay for the harm.
Yeah, and just a comment. The PFAS, that is the chemical that, in layman's terms, everybody talks about forever chemicals. Had nothing to do what we were doing last year with our water system. Totally different set of chemicals.
That's right.
But there was a lot of trying to mash that together. Just these are man-made things, like Grant said, that you can't break them down. They have such tight bonds. And so when we, as people, introduce them into, we put them down your garbage disposal or whatever, our water treatment facilities have a hard time treating that, and it ends up back in the water source. So that's the forever chemicals.
That's
And I'm all
exactly right.
for pursuing that.
Yeah, that's exactly right. And from what I understand, really the firefighting foam was a large contributor of this, and that's why the airports are part of this discussion and analysis, because that was used widely on airports for training, and so a lot of the PFAS chemicals have ended up in those areas. And so again, we're just really preliminarily, the 3M DuPont fund, they were talking 7 figures just for the drinking water, just from those 2 companies.
I agree with your recommendation. My question, if I hear you right, I guess our risk really is if we did the testing, the wells, and we don't have the chemicals. I'm guessing we already know we have this chemical in our water?
Well, potentially, and there was a list that essentially said if you're on this list, then you're in the game, essentially.
Okay.
And as I understand, even if you tested a 0 on your source wells, you still might be entitled to compensation.
Okay, I didn't want to get bogged down there. I still want to move forward with it. My other question is probably directed more at Al, and it's probably not a fair question. Are we making efforts to get this out of our water now? And I look at this fund as a reimbursement of our efforts to get it out of the water. I mean, is there a way for us to get it out of the water? I understand what Jimmy said.
That's the tricky thing. So we're not
Okay,
ready to
I
say
realize
tonight
that.
it's in the water.
Okay.
We've passed all our tests, all our water is clean, our water is passing
Right.
tests, so everybody shouldn't wig out. But it could be. So part of this is testing our water to examine whether or not it is in there.
Okay.
Right.
Which we have to, okay.
There could be de minimis amounts in there that wouldn't make us
Right.
worried. So there's like 3 levels, right? There's like super high level where, we got to take care of this, and then that settlement money is going to go towards taking care of it.
Right.
It could be a little bit where we could need some of the settlement money to take care of it. It's take care of, and then we have it, the rest of it. Or it could be like a de minimis 0 level, but we're still entitled to get money, but we don't have to do anything with it.
Right.
So the first thing really, we need to jump on board and start the testing and find out.
And just to-
I agree with that entirely.
And
So,
just to
but
ti-
in the interim, nobody should lose any sleep.
Yeah, and to tie on that, we're talking about testing the source as well, right? So this is before it goes through the city's cleaning process. So it very well might be that the city is eliminating all of this before it gets into anybody's drinking water. But again, it really, what their focus is on the source and looking there, testing that, seeing if basically the city's being forced to draw water that is contaminated with PFAS and then have to spend the money to clean it out.
I think you already answered this question, but is there technology today to take it out of the water at the city level?
I assume so.
Okay. Okay.
You know.
But I'm fine. I didn't mean to get bogged down on
goes
that.
back to
I know I
good
asked them, different questions, but I agree with your recommendation.
So as long as we do it before the end of the year, get on the train, our fees will be covered for the testing.
The testing fees,
Okay.
yes, sir, that's
So
right.
we'll have no out-of-pocket expenses as well.
That's correct.
Okay.
And the attorney's fees, again, are contingency, so it would not be that the city's paying hourly rates or anything like that.
Okay.
And if they recover $0, then the city pays $0.
Thank you for that clarification. I misunderstood that.
Do you need a motion from us, or you just?
Yeah, I think a motion would be fine. If somebody would make a motion, basically just to authorize further exploration and potentially bringing back a couple of retainer agreements for consideration.
So moved.
A motion and a second on the floor. Any further discussion from the commission? Any public comments? Seeing none, roll call.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Commissioner Cunningham?
Yes.
Commissioner Bray?
Yes.
Mayor Reesman?
Yes.
Thank you all. Thank you all. That's all I have. Thank you.
City Attorney. City manager items.
Just a couple things. If you guys recall, I don't know, maybe 2 months or so ago, through Lake 100, we brought on the services of Levy Consulting as a countywide to examine this subsidy question with tax revenues and that type of stuff. Mr. Levy kind of finished his preliminary report and presented it to the city managers at our monthly luncheon on Thursday. Long story short, he's finishing up that report, which he will provide to the cities and the counties. But at a high level, he did consider that there was a subsidy of municipal. If you're in a, let me say this so it's accurate. Obviously, if you are in an incorporated area in the county, you pay incorporated as well as unincorporated property taxes. So whatever city you pay a millage rate, and as well as the county, and you pay a county property tax whether you're incorporated or unincorporated. Long story short, through those general services provided by county or city, Dr. Levy found that there was about a $25 million subsidy of incorporated cities in total in Lake that goes over to the county. No solutions on what to do with that, but just we had speculated about that. I think the number that I brought up was 50 million. I spoke with the county manager about that, kind of as a catapult into this study. I think Jennifer felt like the subsidy was about 12. So there you go. But Dr. Levy split the baby. I don't think that was not intended. That was, so more on that study to come. But that those numbers may be floating out there if you hear from it. As well, we also had I think an extremely good discussion at the managers' luncheon, and we've made a little bit of progress on the no annexation zone concept, which I brought to your attention, I guess a couple of meetings ago now. I've received some positive feedback back from the county manager about that. We got, again, some good feedback from the manager's luncheon. So where we're at right now is our draft concept is on the county manager's desk. It's only been there a couple of days. I think I sent it to her Thursday last week. So she'll get back to me with some feedback in the interim. Actually, today I had Pam we're trying to put together kind of a local meeting. So everybody who's a party to the 2013 ISBA agreement will need to come back and have a joint meeting on the concept. So that would be the cities of Mascot, Mineola, Groveland, Leesburg, Howey, and the county. I think I named everybody. So we'll try, hopefully before the holidays. I don't know if we'll get before Thanksgiving, but certainly before the holidays in December, we'll be hopefully able to get everybody together and get at the table. So I think that concept seems to be gaining some positive traction. So more on that to come. And then I wanted to wrap up my comments today with congratulations and pointing out Anna Rotterman, our deputy city clerk. The city clerks have a couple of courses they go through where they get their, as we nicely say, get your ticket punched. So Anna's ticket has now officially been punched, and she has now obtained her Master in Municipal Clerk certification, and she received that on October 22nd this year. So congratulations to Anna.
Congratulations, Anna. Is that it? City Manager?
That's all I got.
Thank you. Roll call.
Commissioner Bury,
Nothing tonight.
Commissioner Peterson,
Nothing tonight.
Commissioner Barry.
Yes, I have a couple of things. I'd like to first thank the West Leesburg CDC had their third fall festival on Saturday, which was a great success in bringing the community together. A thank you to Lakefront TV for capturing that footage for us, as well as kudos again to the Lake County School Foundation for another successful year of the Lady of the Lakes Renaissance Festival. It was very, 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 very crowded. So a lot of people were there. So I just want to add that. And I'll let you add the others. I know you have it. No, you go ahead. I know it's on your list.
Commissioner Connell,
No, ma'am.
Mayor Reisman.
Couple things. Thank you to the Leesburg Special Events and their team for putting on a fantastic Veterans Day parade this weekend. Also, this coming Friday, wishing the best to Officer Huser and K-9 Nick. They'll be competing in a K-9 competition again. Also, this coming Saturday is our Flapjack 5K downtown for all you runners. I know we all are. And then thank you to Commissioner Morris and Allison. We attended two grand openings here in the city of Leesburg this morning. And also a happy early birthday to our city manager, which is this Thursday. With that, I will take a motion to adjourn.
I do have one other thing I forgot. Is I've spoke to Al and Grant about this on the Shuffleboard Court property. I mean, I think the property's posted as closed, what have you, as of November the 7th. And I have spoke to Al and Grant about what the timeline was going to be on conveying the property to Forward Path. With the pending lawsuit that is going on, I don't believe we should turn the property over to anyone until the pending lawsuit has been settled by the court system. I mean, in essence, I believe the basis of the suit is we didn't have the authority to give it away. So I don't think we should proceed to give it away until the lawsuit has been settled. And I don't know the time frame of when the city manager or city attorney's recommendation was to execute this deed, but I just don't think we should until the lawsuit has been settled.
Let me just add on to that, because Commissioner Cannell did bring that to my attention. It was, and I think we spoke on the 6th or something, the Wednesday before the Thursday, about a day before. And actually, I hadn't given it much thought. So you all approved, so just let's revisit timeline, because what we do need is some clarification on when you would like the official deed to be signed by the mayor. So the mayor signed the deed for point of order, and we destroyed that document because subsequent to your all's direction to dedicate the property, I don't remember what meeting that was. It 3 or 4 meetings ago. We received contact from the Shuffleboard Court, and I think this chronology is important, so bear with me. Shuffleboard Court contacted me directly, said that they had a couple of events planned for November. And they asked if they could still use our court for that event. Because there's a lot of planning involved with the concept, the concept was the donation to the property to Forward Paths. Forward Paths had a lot of work to do as far as professional services, surveys, planning, engineer, all those things. So there was considerable time between when Forward Paths really needed the property and continued use. So I used my administrative judgment. I think I reached out to each of you and said, hey, let's make the official deed November 7th. The Shuffleboard Court seemed happy with that. Y'all seemed content with that, and we were able to oblige that request. So while the Shuffleboard Court was happy with that, they then filed suit against us after we extended the deadline. And then the day, I think it was on the 6th, the attorneys Mr. Sabatini, representing the shuffleboard court, filed an injunction. Okay, so the injunction at that time, Grant took it as to scrambled off to set a date, a hearing date to speak about the injunction. So an injunction, a court action, would officially stop action from the court. So anything that we would do to the property or Forward Paths or whoever owned it, that injunction sought to stop any movement on that transaction. So Grant started prepping and got dates out, and as he was doing that, Grant received a second notice from the court that not only was an injunction filed, but then Mr. Sabatini amended his injunction filing to file an emergency injunction. So that action was then quashed by the court. So we're back to square one, which is there is an injunction on the property. So that hearing is now set to I'm going to turn this over to you in a second, but let me get this out, Grant. So because I'm going to give you my recommendation as your management, and then hear from Grant, and then we kind of blend the two together. So we are now back at, there is a question for an injunction on the property. That hearing is set for November 13th, I think at 10 a.m., if I'm correct.
Yeah, that's
So we
Thursday at 10.
anticipate that the judge, based on that hearing that day, will determine whether to grant the injunction or not. I think Grant has also filed a motion for dismissal. That motion isn't heard until January. So pretty much from November 13th to January, barring any other motions or actions filed by each side, we'll sit still. My suggestion for the commission, and then Grant, please opine, is you probably shouldn't do anything with the property until the motion on the injunction is settled. So if a motion on the 13th, if the motion for the injunction and the injunction is dismissed, my suggestion to you all is to have the mayor execute the deed and put the ownership of the property in the hands of Forward Paths once the question about the injunction is settled. I do not see risk in that for the city. If we go through this lawsuit, we lose, the city's not out anything. We don't have finances involved. We don't have any planning. So whatever the determination of whether you acted correctly pursuant to the charter as the lawsuit alleges, you guys I don't see you have any financial or legal or other type of risk, because your worst sum game is going to be the court orders that Forward Paths gives the property back to you. I don't think that's the same risk for Forward Paths, and I've talked with Denise Burry about that, and expressed to her my opinions on the matter. But I think the important thing from this body is that I kind of, depending on where you want to go, and obviously it's, the vote was a 4-1. I don't see the conversation that flavor of the commission changed. So in the affirmative, I think that the quicker we can get Forward Paths onto the city side and have them attached to that property, I think it does nothing. I think, and Grant, I'm not going to speak for you. I'm going to stop here in a second. But, I think we have a very good case. I think Grant feels that. I think that we have a good case on its own. I think if we encumber Forward Paths into the case by signing that deed, then our case becomes even better. So I think I think we are stopped until the 13th. See where the injunction goes. If the injunction is awarded, then I think we probably still need to stay stopped and see what the term of the case is. But if the injunction is overruled, then I think we need to move forward. So Grant, why don't you throw in the legal stuff now?
Yes, thank you, Al, for going through that. I think a lot of what Al said is pretty much right on. I'll just just to clarify a couple of things as far as the procedural posture of where we are. So they have filed a complaint asking for a declaratory judgment that the city violated the city charter by transferring the property, alleging that that is an activity of the city prohibited by the charter without a referendum, and they've asked for an injunction broadly to prohibit the transfer of the property. Now, filing these things on their own doesn't stop anything. It's just somebody filing a lawsuit and making allegations. And that's where we stand right now. We have somebody filed a lawsuit and made allegations. There's no court order that says you can't transfer the property. There could be a court order on Thursday that says you can't transfer the property temporarily, but we don't know. And so, I think perhaps there's some wisdom in waiting and seeing how that hearing plays out. But honestly, I don't know that it really matters as far as where we are procedurally. There's nothing that prohibits the transfer right now, unless and until there's a court order that does prohibit the transfer. I question why a temporary injunction wasn't sought sooner and waited until basically the transfer was about to occur. I think probably they would have done themselves better had they asked for it sooner. But that's where we are. We have a hearing Thursday, and we'll see what the court says at that point. I agree with what Al said as far as the exposure. I think it's pretty minimal for the city. I don't see, if the injunction's entered, if there is a declaratory judgment that the city violated the charter, then I think the worst day in court is the property goes back to the city. Doesn't hurt the city. As Al said, there's really no money into the deal. The city's agreed to donate the land. So I don't know what the downside is. Maybe there's some just extreme, worst imaginable day where the court would order the city to reconstruct the shuffleboard courts, but I think that's almost a non-existent possibility. Even if you go with their argument that the shuffleboard courts is an activity of the city, nothing prohibits the termination of an activity of the city in the charter. So the city could shut down the shuffleboard courts whenever they want, and there would be no referendum requirement. So for the court to send it back and then require the city to reconstruct if Ford Pass had demoed it, I just really don't see that as any kind of possible outcome. So I think the worst day in court is the judge says the city was wrong and the city gets the property back. I don't know where everybody is. I certainly I agree. I think that this is a healthy discussion for everybody to have, for Commissioner Cannell to bring up, because I do think, again, it's worth everybody understanding where we are and what currently is in place and where we could end up, and make a decision before things are transferred. But I think the risk is pretty minimal to move forward, and I don't think it matters whether you wait until after. Honestly, I think there's an argument it could be harder to undo it if the deed is delivered than if it's not delivered.
So that's different than my advice. You're saying go ahead and execute
I
the
think
deed now.
that it's harder to unwind the injunction, or it's harder to unwind the transaction if it's already done. Typically, injunctions are prospective. They're not undoing things that have already happened.
Well, I mean, you got the injunction thing coming up Thursday.
Yes, sir.
And then you've got the regular lawsuit thing in January.
Yes, sir.
So we're talking, what, a couple months? If you went ahead and transferred the deed, you're saying, Leesburg, is basically held harmless on anything, we just take the property back. But if the shuffleboard courts were demoed during that time period, we're going to get a piece of property, a raw property back that all our courts have been removed Why, I don't understand why we would even take that risk. Why wouldn't we just wait the 2 months and let this be resolved one way or the other versus taking the risk of giving the property away, then find out we have to get it back and we've lost, what, $500,000 worth of shuffleboard complex? I mean, it doesn't seem to make a lot of sense to me. It doesn't seem like it's worth the risk over 2 months.
Yeah, you are right to point that out, that if the courts are demoed, then the city gets the property back, sans.
Exactly, yes.
Shuffleboard courts.
And yes, I don't know why we'd risk potentially $500,000 worth of improvements removed to find out, just wait 2 months.
Well, I don't think that'll be solved in 2 months. So the temporary injunction hearing is Thursday.
Yes.
We'll know something about that,
Yes, right,
obviously,
sure.
at that point. If a temporary injunction is not entered, then I don't know what the timeline is on this lawsuit. You know, January 28th is our motion to dismiss hearing. If we prevail on that motion, they will most likely get another 20 days to refile. Then we'll get our 20 days to respond once they refile, which could be another motion to dismiss, depending on. So, you know, maybe we answer and then we move into discovery, move into trying to get a trial date. It's not entirely clear sort of what the end date might be on the litigation. You know, it's very unclear, I guess I would say. It did take 4 months to get a 15-minute hearing. You know, we were able to get the emergency hearing scheduled sooner. It's a little bit different circumstances, but sort of a normal procedural hearing, the time frame seemed pretty far out to just get 15 minutes with the judge. So not real sure how long that might hang on.
Grant, so am I understanding transferring a deed, does that mean transferring and demolition? Or that's just transferring the deed title?
That's just so the city's, you know, voted to transfer it. What Forward Paths ultimately would need to demo the courts in order to improve the property and do what they're trying to do. But that's completely on, you know, up to Forward Paths. Once the city has signed the deed, delivered the deed, and recorded it, or just delivered the deed to Forward Paths, honestly, then it's up to them what happens to the property at that point, as long as it's consistent with the covenants, because it would be going over with some covenants and restrictions on it. So as long as what they do is consistent with the restrictions that you all approved previously, then they can do what they want.
So the purpose of the injunction was to stop, correct? No,
There is no
intervention.
injunction. There's a request for an
Request for injunction, okay,
Yes, ma'am.
thank you.
So in essence, you could give it away, Commissioner Barry, and then they could demo the courts out, and you find out in 6 months from now, they have to give it back, and now we get the 1.6 acres back with no shuffleboard courts on it.
I can't speak for the whole commission, but I will take your recommendation on, you know, doing a transfer now or after the injunction. I mean, part of me, I would say wait for the injunction, but if you say you're comfortable doing it now, I would support that. Whatever you recommend on that. As far as the shuffleboard courts, you know, this whole lawsuit is just, I don't know the right word, ridiculous, because they can stop us from transferring it, but if we don't transfer it, we still own it. We're not going to resurface or do the shuffleboard courts. So I have no problem transferring it. I don't care if Forward Pass knocks them down, because we're not going to build shuffleboard courts. That's my position.
Well, you wouldn't build them, they're already there, you just put new
I'm not going to
surface on
support
them.
resurfacing them.
Why? What is your issue with the shuffleboard courts, Mike? I mean, seriously, you're
I
wanting
could
to
start
spend
with-
you're wanting to spend $1 million coming up here on 12 pickleball courts. We already have 12 in town at Pear Park, but you don't want a single shuffleboard court in this city. I just don't understand your issue with the shuffleboard.
Well, I'll start with how they handled the first meeting by coming here and demanding that we have the shuffleboard courts resurfaced by October 1.
I don't know there was any demanding.
A gentleman pounded his fist on that
I
podium and
don't know there was
demanded,
any
so I'll just
demanding.
stop
I
right
think
there. I'm not
that's
going to argue that one with you.
drama with you.
Well, yeah, go back and look at the video if you need to. Yeah, I don't think they handled this very well. We finally determined the only people using it is the Shuffleboard Club. I believe we determined there are 6 members that live in the city and pay taxes. I think there was an argument it might have been 7. Whether it's 5, 6, 7, it's a very nominal number. They secured the shuffleboard courts. I realized it was locked, then it was a dummy lock. We went through all this. But my point is, in my 7 years on the commission, I'm not aware of anybody complaining that they couldn't access the shuffleboard courts. So the residents, in my opinion, don't care about shuffleboard. They're not playing shuffleboard. Yes, we have a club, and I have some sensitivity to that club, but they have other courts in Leesburg, not in the city limits, but there are courts available. So I supported the transfer to forward pass. I just want to move forward with it. I am over shuffleboard, whether you agree or not. They lost me a long time ago.
Well, let me ask you a question, because you're talking about there's like 5 or 6 of them live in the city. Well, you're building an $11 million sports complex at Susan Street for rugby. How many rugby players do we have in town? I mean, we get silly with this thing. If they don't live in town, then we're not supposed to.
For the record, I voted against that, okay? I
what?
voted against that, for the record.
Yeah, I would just like to make a comment, if it's all right. The difference in shuffleboard and in Susan Street is that your youth, all your youth programs, all your rec programs are going to be run through Susan Street. So the usage by your tax-paying families here in Leesburg on those facilities is going to be.
We have rugby here in
We
the
just
city
are
for-
building rugby fields if we can recruit those kind of tournaments. That's the largest field that you need. It's rugby
I
fields,
get it.
lacrosse fields, soccer fields, football fields.
I get what you're saying, Jimmy,
Yeah.
and like I said, I don't have
But
any
the difference,
issue
let
with
me just
Susan
finish.
Street. Go ahead.
There is no one playing recreational shuffleboard from Leesburg. There was, on their membership, there was 5 or 6. That's it.
But you're bringing people into the city. That's the whole concept of some of this stuff. That was the concept of the Susan Street was sold. You're bringing in economic tourism into town.
You're
I mean,
also
we're-
spending $500,000 to do that.
$500,000. All they wanted was resurfaced.
No, they did not.
Yes, all they wanted was the courts resurfaced. They were going to resource tennis courts, and you were going to build some pickleball courts.
Did you read their proposal that they sent in?
Whatever their proposal was, that's not what was spoke about. Me and Al have spoke about this. It was resurface the courts, resurface tennis courts, and build some pickleball courts. We're going to make this the Palmetto Recreational
We're
Complex.
moving away from.
I agree with you. We're getting
finishing.
off of it.
Yeah,
But anyway.
that's
So
not
we
the-
have 2 different recommendations on the floor from our city manager and our city attorney.
I'll just clarify again briefly. I mean, I think, again, the city, there was a decision made. I don't think that I think I understand the idea of waiting until after the hearing. It's 2 days from now and seeing what happens before doing anything, and seeing what the court decides. I can understand that perspective. I don't think that's unreasonable. I think that, again, the risk is pretty low, barring, receiving property back with demoed courts, and what do you do with that? Is there harm to the city there? I understand that. But I think that most of the downside is really on forward paths. I think if this comes back to the city gets the property, and again, it may not have the shuffleboard courts, but you get the property back. You're not paying fees, and you're not paying a bunch of money to somebody for doing anything wrong necessarily. There's no development cost sunk into it. So I don't know if it's a harmful decision if the judge says send it back, particularly if it's been a couple of days since it was signed. I doubt they would be building anything in the next 2 days. But I think also, there are advantages to just continuing down the path that you started. There was a decision made. There's a lawsuit filed with allegations, but there's nothing that says that you've done anything wrong. And so if you continue forward as though you had always planned, then it looks like you're just, again, moving along and going with the plan you always had. But again, if you want to wait until after the hearing, it doesn't bother me. I'm happy to report back to everybody. But from my perspective, it doesn't really make much difference if the decision is to go ahead and sign the deed, whether you do it now or whether you do it Friday.
In the essence of time, I'm going to move forward and make a motion that upon the injunction being dismissed, that we go ahead and transfer title to Forward Pass.
The injunction, just to clarify that, I'm sorry.
No, you're
to
fine. Thank
jump
you.
in, Commissioner, but dismissal is unlikely.
I meant the
particularly
injunction. Well, yeah, I used the wrong lingo. I meant
If-
prevailing on the injunction is what
Yeah,
I
if the
meant.
temporary if the motion for entry of the temporary injunction is denied, then
Okay.
you would recommend signing the deed at that point.
That is my motion. I'm sorry, I don't have all the legal jargon correct.
You're good. I understand.
So we have a motion on the floor. Do we have a second?
I'll second it.
So we have a motion and a second. Any further discussion? Any public comments? Seeing none, roll call on the motion on the floor.
Commissioner Berry? Yes. Commissioner Connell?
No.
Commissioner Burry?
Yes.
Commissioner Peterson?
Yes.
Mayor Reesman?
Yes. Yes.
Now that we have had this discussion, there's honestly, this discussion's brought up another matter which leaves, that I need direction on. Okay, so there is, and Commissioner Cannell talked to me about this as well, so you guys need to direct me what you want done. The fiscal year 26 budget allocates $1 million for what we dubbed the Palmetto Street Sports Complex. When that concept was introduced in July, that concept was to resurface shuffleboard, build pickleball, and resurface the tennis courts. Through the summer, it is my opinion, through discussion, that the commission changed that direction when you donated the property of the shuffleboard courts to Forward Path. Therefore, when we contemplated and approved the fiscal year 26 budget, there was $1 million for, as I would interpret it, pickleball, and resurface the tennis courts. There was no contemplation of anything to do with the shuffleboard courts because potentially it's going to Forward Paths. So we have sent into the marketplace an RFP to start design of pickleball. I need to know if that is the direction of this commission. Do you want to include shuffleboard in any part of the $1 million allocation? Yes or no?
My answer is no, and I just want to piggyback off the pickleball and the
And on
tennis.
this one, I would prefer a motion
Okay, I'll
that
go
you
there.
vote on, so it's clear the direction. And the motion would be something like, move to instruct the city manager to move forward to procure an engineer to design the Palmetto Street Sports Complex, which includes resurfacing the tennis courts and constructing new pickleball.
And I was just going to add, I believe it includes some parking if there is space
Parking,
available.
Associated parking.
Okay.
So the motion would include direction to start on pickleball construction, resurfacing tennis courts, and associated parking. Is that your motion?
Yes, that is my motion. So moved.
There was some discussion before we make a
No,
motion.
you gotta have a motion to debate it.
Oh, yeah.
So moved.
So we have a motion on the floor. Do we have a second?
Oh, I second it,
All right,
please.
now we'll open it to discussion.
Okay, I mean, was there a mill or 1.5
It's a
million? Okay, it's a mill. You've got 12 pickleball courts in town now at Fair Park. Not counting the other retirement communities that all have pickleball courts in them. I can think of at least 3 just offhand in South Leesburg, but I don't see to spend $1 million on pickleball courts and completely shut out the shuffleboard people. I think if you want to spend $1 million, I think the money should be split between 50% pickleball and 50% shuffleboard. I just don't think you dump it all into pickleball and shuffleboard people get nothing. I mean, I just don't think it's fair. I mean, they have no courts at all now, and we have none publicly in the city. You have 12 pickleball courts, but you have no shuffleboard. I think the money should at least be split.
Commissioner Connell, I'd just like to make a comment. If I might, I can recall in our budget discussion, it was tennis courts and pickleball.
No, ma'am. The original proposal was to resurface the shuffleboard. This came up before the discussion with Forward Path came about.
Yeah, this was during the budget meeting. That's what I'm referencing to the
Yes.
notes, yes. I don't recall.
It was resurfacing of the shuffleboard, the original proposal of the
Okay.
Palmetto Sports
I'm not going to,
Complex.
all right. I have to refer back to the minutes, but I just thought it was.
So
there was
he's
a-
correct.
Okay.
So,
all right.
so just for clarification, when you say there are pickleball courts in the city of Leesburg, you're talking about Pear Park, which is not the city of Leesburg.
It is the
That's-
city of Leesburg. Pear Park is in the city of Leesburg.
Okay. It's a county park.
It's a county park, but it's in the city limits.
Is it?
I'm almost positive it's in the city limits.
Wow. That's new to me. But closer to Leesburg, there are multiple shuffleboard courts.
Where?
Hawthorne?
Those are private communities you can't go to if you're not a resident.
So a third of the shuffleboard club that lives in the villages, they've got tons of shuffleboard.
Well,
clubs.
how about the people, you know, everybody's assuming nobody uses these shuffleboard courts, but this group of people that play in this club, I would think other people would play. I do think other people play. You've got 12. I just don't understand the resistance to give something back to the shuffleboard people. You take 18 or 20 courts away, and now all of a sudden they get nothing, but we're going to put $1 million into pickleball when we already have 12 courts in the city.
It's real simple for me. The residents of Leesburg want pickleball.
We don't
In
know
my
that,
opinion-
Mike. Have you seen a referendum done
Okay,
throughout the city?
okay, I'm not going to argue. I made a motion.
It is the feedback you got. The feedback you got from the Recreation Board, which is the board that you appoint.
So this
that
never even went to the Recreation Board.
The Recreation Board said they wanted pickleball.
I know, but it never went to the Recreation Board to even do away with the shuffleboard. That never even went to the board. That was one of my issues. That's we never even got a recommendation back from the Parks and Rec Board on giving the shuffleboard property away.
So we have a motion and a second on the floor. Any further discussion? Any public comments on the motion on the floor?
What is the motions? Tell me again.
The motion on the floor is that the Palmetto Street Sports Complex $1 million allocation for fiscal year '26 includes pickleball, resurfacing the tennis courts, and associated parking.
So
It has nothing to do with shuffleboard. That's the motion.
And if there was an order, Mike, would the order be tennis court resurfacing for sure, and then whatever shuffleboard, whatever pickleball
That's what I would like
we
to see.
get?
Yeah, and I don't think we don't need to compete with Pear Park. We don't need some big number of pickleball courts. So I mean, I trust.
What we can get.
Yeah, we'll see what we can squeeze on this parcel with adequate parking.
The tennis courts are still utilized by the high school.
Yeah, and
That's,
when I
that's
drive
the
by at
first and
night,
foremost.
there's people there every
That,
day.
I'm just want to make sure I'm understanding for my point of reference. And the pickleball courts were to be added because that is a popular and most needed and requested sport. So that's where I'm understanding, and that's where I thought we were going when we first started the conversation, so.
And that's what I thought too.
Okay. Public comments? Any public comments on this item?
Josh Brewster, 1515 Crest Avenue, Leesburg, Florida. I've been in the city for 20 years, and I had no idea that there was a shuffleboard court in this city until the shuffleboard people came and started their stuff. So, and I know pickleball is huge for all kinds of people. So that's all I got.
Thank you, Josh. Any other public comments? Seeing none, we will have a roll call on the motion on the floor.
Commissioner Connell?
No.
Commissioner Berry?
Yes.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Mayor Reason?
Yes. Any other things for the good of the order of the meeting? All right. Take a motion to adjourn.
So moved.
Second.
Meeting adjourned, 7:03.